This will be a much different show than I normally do. I figure it'll help me too. It'll help me understand and digest the massive volume of information that was submitted to the court in the Lynn Haven corruption case by the defense, uh, by James Finch, Margot Anderson, the Lynn Haven former Lynn Haven mayor. This was submitted last week to Chief Judge Mark Walker. They are both scheduled, I don't know if it's scheduled, but they're both supposed to go to trial. But it may not go to trial because the defense has filed a motion to dismiss. Judge Walker wanted to see evidence. So there was a 3-day-long evidentiary hearing that included incredible testimony under oath by investigators, by the FBI. It was incredible, absolutely incredible. So I figure what I want to do is I want to read the whole damn thing with you so that you can see it. I don't know yet if I'm going to read all of the footnotes, and you'll see as I go through it, the way that it's written, I may skip portions of it. Much of this is going to be too much specifics for you, probably, because unless you've really been following it closely, you're not going to know who all of the players are. So I'll tell you the names of some of the players up front. And if you really want to watch this closely and try to understand what the filing is, what the defense filing is, it's basically a recap of the evidentiary hearing and why the defense believes that the case should be thrown out. Basically, the reason they argue, the defense, that the case should be thrown out, essentially is malicious prosecution. I think, and you'll see as we go along here, what makes this case very different than just about any other federal case is that if you are ever indicted and stand federal charges, you will not get to see what the prosecution has shown or the law enforcement has shown. In this case, the FBI mostly. I believe, mostly the FBI, because these are federal charges. But it was a joint investigation with the sheriff's office. So you would not be able to ever see what they told the grand jury in order to get an indictment against you. There were 3 grand juries in this case because it went on for so long. A grand jury, I believe, goes 6 months, and a grand jury is composed of about 15 to 20 people, regular people. It's all very secret. Less than 1% of the time, you get to see what was said in the grand jury. This is one of those times. So this, and it's really incredible. It's really incredible. Remember, what we're looking for here is, do we see evidence? And of course, the defense isn't going to show any evidence. This is what I'm going to read to you is the defense, right? They're not going to say that there's evidence that we're guilty. So remember, this is a defense filing, but it is a defense filing of evidence, transcripts from the grand jury, 302s, which are FBI notes when they investigate witnesses and targets. It's grand jury transcripts. It's testimony under oath. So this is packed full of evidence making an argument. It's also packed full of court precedent. Now, I may not read all of the court precedent either. So when I say, I'm going to read this in its entirety, this will probably be at least 2 shows. So this is part 1, right? It's long. It's 76 pages long. And I don't think my voice will hold up. I don't think your interest will hold up to go through all 76 pages in one day. So I might do it in 2 days. I might even do it in 3 days. I don't know. We'll see how it goes. But what I'm going to do my best to do is to read it and show it to you while I'm reading it. So you're going to see it as I'm reading it. You'll be able to read it yourself. You'll be able to screenshot it. You'll be able to go back and, look stuff up for yourself, all that kind of stuff. But I think it is super important that you see this stuff. So because I know a lot of people haven't, you know, so let's do it. But before I do, let's go over. I might even have. I don't know if I have it at my fingertips or not, but the players, the main players involved here. So when you hear these names, this is who we're talking about. Of course, you know, former Mayor Margo Anderson. You know, James Finch. These are the two defendants. Other people, and I'll try to tell you who they are as we go through. Other people involved are going to include the FBI agent, Larry Borghini, the sheriff's office main investigator, Jimmy Stanford, former contractor Derwin White, who passed away unexpectedly last year. It appears he was a main target. Greg Wilson, who is a former top prosecutor in Bay County up until 2016, who plays a very big part in this. Chris Forehand, who is an engineer, who's all over the indictments. He was the city engineer, who was given at least full immunity on some things. I'm not quite sure yet because it hasn't been. I don't think it's out yet, but it's what they said in the hearings. So I'm going to read all this, as much of it as I can, for you. Again, I'll try to tell you who the players are, but I think this will have some value. I'm going to try to read it straight. So where are we now? The defense has submitted their filing on why they think the case should be thrown out. The prosecutors have a chance to respond. They did not respond fully in the court. They refused to. Didn't refuse. They just said they chose not to, which was a real shock. And then the defense, I believe, has another chance to respond before the judge makes his final ruling on whether this goes to trial or whether it's dismissed. And if you hear dismissed with prejudice, that means it's over. They can't go back and do any part of it again. Dismissed with prejudice is what the defense wants. Okay. So again, different kind of show. But I'm going to start and I'm going to show you, you're going to see the filing. And we're going to go through it. I'll read as much of it as I can, as much of it that I think is important. And we'll go from there. Very different kind of show. But I want you to be as up to date on this as possible. A lot of people have opinions about it, obviously, including me, including you. But my goal is to have our opinions informed by the evidence. Okay, so I'm going to start reading this in just a moment. It's a hot time in Florida, and my friend Ryan can make sure your air conditioning is running at peak efficiency. He could even install a new one, built to a higher standard, American standard. Find out more at pcairrepair.com.
When your life is on the line, hire the lawyer who lives in our community, works in our community, and worships in our community. I'm El Saulene, your Panama City Beach lawyer. 850-215-0628.
All right, let's get to it. Here is the filing. This was submitted last week. I'm going to make it so that you can see as much of it as possible as we go through it. I think that's a pretty good shot of it. All right, so this is the United States versus Margo Anderson and James Finch. This is their defendant. Finch is redacted. There are only small parts of it are redacted. Post-evidentiary hearing brief. All right. So the United States district court judges are granted leeway to fashion appropriate remedies for violating its orders, as well as constitutional rules of fair play. Indeed, consistent with the Constitution, fashioning appropriate remedies is the very nature of discretion and the law itself, as explained by U.S. Supreme Court Justice Felix Frankfurter. The civilized conduct of criminal trials cannot be confined within mechanical rules. It necessarily demands the authority of limited direction entrusted to the judge presiding in federal trials. including a well-established range of judicial discretion, subject to appropriate review on appeal. Such a system as ours must, within the limits here indicated, rely on the learning, good sense, fairness, and courage of federal trial judges. And that is the case law right there. An indictment pursuant to the federal court's supervisory power. Okay, so they're citing it. And I'm going to pass over most of the case law that is cited. Okay, so this is just backing up what they just said. In this case, the defense says, learning, good sense, fairness, and courage under the law warrant dismissal of the second superseding indictment based on all the circumstances. The government has flagrantly and repeatedly violated this court's orders, producing discovery materials well past court-imposed deadlines, as detailed herein. Remarkably, the government even produced court-ordered materials, including significant Brady material, both immediately prior to and after the recent evidentiary hearing that was held about 3.5 weeks ago. Now, what Brady material is material that prosecutors should turn over, are required by law to turn over, that could be exculpatory, that could show that there is, that basically could be shown to give the defendants a not guilty verdict. I don't like to use the word innocent because in a court of law, it's not guilty or guilty, right? So I try to avoid that term when we're speaking about the law. Look at this. The court, in this case, ordered the government, the prosecutors, to produce all materials to the defense no later than March 1st. Despite this order, the prosecutors, I'm going to say prosecutors, when I say, now I'll just say the government, made multiple late productions of materials to the defense in violation of the court's order. On March 4, the government produced new FBI 302 interviews. That's a form, a 302. Okay, that is a form where the FBI agent fills out his notes and formalizes notes where he interviews subjects. Interview reports of David Mickey White and Bay County Sheriff's Office Major Jimmy Stanford, as well as miscellaneous files related to Chief Assistant State Attorney Wilson. That's Greg Wilson. On March 5th, the government produced a 302, the formal document, of an interview with Sheriff Tommy Ford. So the FBI interviewed Sheriff Tommy Ford. On March 9, and these were all submitted to the defense after the deadline. On March 9, the government produced a 302 of Mark Bailey, along with 2 grand jury exhibits. In addition, the government has repeatedly presented fatally flawed charging documents to multiple federal grand juries, routinely violating court orders and other basic rules of law. For example, the government has repeatedly violated fundamental tenets of joinder, as well as returned a flawed indictment containing a substantive count, violating the statute of limitation on its face. And you can look at number 4 if you want to look for details. So I don't know if I'm going to read all of those, but I'll read some of them. Most recently, despite a clear court order dismissing the overreaching conspiracy count in the superseding indictment based on improper joinder, the government orchestrated the return of a virtually identical overarching conspiracy charge in the second superseding indictment. The overarching conspiracy count includes near identical language despite the court's previous order of dismissal. Forehand, that's Chris Forehand, the city engineer, certified copies of June 9, 2020. And these are the things that they're saying were not turned over, were turned over late. Upon being notified, that's number 4, that the substantive counts violated the statute of limitations on its face, the government declined to agree to the defense motion to dismiss. The defense filed a motion to dismiss, which the court promptly granted. As a result of this repeated misjoinder or error, the unfair prejudice to defendant James Finch in the latest Pensacola grand jury presentation, remember there were 3 grand juries because of the length of time of this whole thing. Nearly half of his conversations with former Assistant State Attorney Greg Wilson. On March 29, 2022, the government produced 6 redacted FBI reports from confidential human sources, CHS, confidential human sources. The government then produced additional agent notes, those are the 302 forms, at 8, late. They basically turned all of this late. This is what's crazy. A lot of some of what the government turned over late occurred after the conclusion of the April 6th evidentiary hearing. The government produced additional critical Brady material that the government must turn over to the defense that might be exculpatory. By email dated April 13, well after that, we asked the government if any additional material would be forthcoming. The government has yet to respond. This was done last week. Maybe most egregious, however, is that the government repeatedly presented false and misleading information to multiple federal grand juries in ways designed to irretrievably prejudice the defendants. A federal grand jury presentation can forever change a person's life and livelihood. Instead of handling the multiple grand jury presentations in a careful, surgical-like way, consistent with due process, requirements, and Department of Justice guidelines, the government repeatedly and indiscriminately poured in 3+ years of factually inaccurate information via a single witness who ultimately admitted to providing false information to the grand jury in this very case. After presenting testimony only from the now former agent, FBI agent, the government submitted a complex, multi-count, multi-year, multi-defendant second superseding indictment to the novice grand jury, the new one. The grand jury complied with the government's request, reviewing the proposed 58-page second superseding indictment, deliberating and voting yes inside of 2 minutes, confirming that the second superseding indictment was returned within 120 seconds. Let's see what evidence they have here in the footnotes. For example, in a previous hearing, the court made abundantly clear that improper reference to the overt act that Finch paid Anderson's attorneys would subject the government to a mistrial. Despite this express admonition, the government nonetheless still included the information as an overt act in the second superseding indictment, mentioning it 3 times to the Pensacola grand jury presentation. Each time the government failed to give the Pensacola grand jury any type of limiting or cautionary instruction, as this court most certainly would have done in a jury trial. As demonstrated herein, we submit that this same witness testified falsely during the evidentiary hearing. The second superseding indictment relates to highly presidential evidence of ECS and world claim allegations. The Pensacola grand jury heard this evidence without any limiting or cautionary instruction, despite the court's order ruling stating previously that the government could identify no facts alleged in the superseding indictment tying to world claim or ECS schemes to the remaining allegations against Finch. Respectfully, such grand jury misconduct is inexplicable, and unfair prejudice to Finch, the unfair prejudice to Finch is incalculable. Now, the only reason that the defendants know this, again, remember, is because the grand jury testimony, the transcripts, the judge ordered them to be released to the defense. That only happens in less than 1% of the time for defendants. So normally, if you're ever indicted, you have no idea what they told the grand jury. Even if the judge tells the prosecutors, you cannot say this to the grand jury, nobody ever knows. But this time we do know. Finally, The government intentionally violated and attempted to violate the defendant's Sixth Amendment constitutional rights that has to do with attorney-client privilege, knowing that such violations would infringe upon the defendant's attorney-client privilege. In short, over the course of many months, the government enlisted a disbarred former state prosecutor, Greg Wilson, who knew many of the represented parties in this case, including Finch. In no uncertain terms, the government operative encountered the represented parties, including Finch, engaged in conversation about this case, and then reported that information back to the government by violating every procedure and protocol known to attorneys and agents alike. The government improperly gathered and attempted to gather privileged and sensitive information to which it was not entitled. The government then intentionally declined to disclose these encounters, hid the notes documenting the improper contact, failed to convert the notes into formal reports, and ultimately submitted false testimony about the entire sordid episode. We submit that the government's conduct was unethical and illegal. The conduct only came to light due to this court's order requiring that all agent reports and notes be produced, an order that even today has not been fully complied with. Again, this court filing was submitted last week. As a result of these repeated flagrant failures, dismissal of the second superseding indictment with prejudice is the only appropriate remedy, as more fully described below. The defense fully respects that that dismissal of an indictment is an extremely serious sanction, and that such a decision must be approached with caution. And then they cite a court precedent. The government's actions and repeated misconduct in this case, however, weren't the most serious sanction. And again, they cite court precedent, which they say should be court dismissal with prejudice, explaining that as a result, such a result was appropriately within the range of reasonable and appropriate remedies. 2, violation of court discovery orders. As demonstrated at the evidentiary hearing, again, about 3.5 weeks ago, and as detailed herein, the government repeatedly and intentionally has violated the court's orders regarding the discovery and production of documents. Here it says the government still has not provided the signed written immunity agreement of former Assistant State Attorney Greg Wilson, testifying that he met with the lead prosecutor and now retired Agent Borghini in Tallahassee, and Greg Wilson said he signed a written immunity agreement. This, of course, is a separate violation for failing to produce the oral immunity given to the former Assistant State Attorney Greg Wilson, that he was, quote, this is what Greg Wilson said under oath at the evidentiary hearing. He said that the FBI authorized him to commit any criminal act short of murder in order to give information, to be an informant, to give information to the FBI. That is what he said under oath. It doesn't mean it's a fact. It means it's what he said under oath. And it is yet another violation in failing to timely produce Agent Borghini's handwritten notes confirming contact with represented parties being a target who has a lawyer. Okay, that's what a represented party is. Anybody with a lawyer is a represented party, which somehow were never transcribed into FBI 302 reports as required by FBI rules. In short, the government attempted to suppress this extraordinary Brady conduct as well. Remember, Brady refers to possible exculpatory evidence that must be given to the defense. A, history of late and withheld Brady material. On March 18, 2021, the court entered a discovery order confirming the government's duty to disclose all exculpatory evidence as required by Brady v. Maryland and its progeny without a request by Finch. And then it cites the source there. On March 24, Finch requested general and specific discovery pursuant to the March 18 discovery order, including all information or material within the scope of Brady v. Maryland. On March 31st, 2021, the government provided a written response to Finch's request for Rule 16 discovery. The government represented that the United States does not have information or material at this time, this is back in March of 2021, which may be favorable to the defendants on the issues of guilt or punishment, citing Brady v. Maryland. The government also took the position that defense discovery requests may include information to which the defense is not entitled and information that may or may not exist. Quote, finally, if your discovery letter includes requests for information to which you are not entitled, or the pretrial order of the court, please be advised, the government said, that the failure of the United States to respond directly to those requests encompassed by the federal discovery rules should not be construed as any representation as to the non-existence of any requested information. On May 14, 2021, Finch responded, seeking specific clarification as to the information that may or may not exist. We also identified several individuals who were interviewed by state and federal agents requesting those reports. This is over the last year or so. Many of these witnesses were involved in the Lynn Haven contracting business, participated in city government, or were contextually identified in the indictment and superseding indictment. This information was not provided by the government in the initial discovery response. Even after the defense specifically identified Brady material, the material was not willingly produced. Instead, the government pressed for an all-encompassing protective order on the basis that the defendants were improperly disclosing discovery material. When challenged to support this allegation, the government altered its argument, requesting the court enter an overly restrictive protective order without precedent or justifiable cause. It was a clear attempt to control materials to which the defense was entitled. The court rejected the government's overreach, summarily denying the government's attempt to unfairly restrict our review of discovery, rejecting the discovery's request to retroactively impose restrictions on documents it has already produced, and holding that the provision limiting the defendants, to reviewing witness material at their counsel's office is overly restrictive. Let's look over this footnote. The government's April 1st, 2021 production included witness statements from only Margot Anderson, Adam Albritton, James Finch, and Antonius Barnes. The July 19, 2021 production included 53 reports of witness statements, nearly all of which were prepared and available before the superseding indictment. Much of the new information, quote, new information, that was provided contained classic Brady, Giglio, and Nape material. For example, witness statements contradicted each other. Many of the reports contradicted fundamental theories of specific allegations in the indictment. For instance, Joel Schubert, a former Lynn Haven city manager, who is now, by the way, the assistant county manager, stated that he was blah, blah, blah. That's redacted. The indictments portray just the opposite narrative, falsely suggesting facts in the worst possible light to the grand jury, and in this case, in the indictment. All right, so now we're down here. After repeated requests by the defense on July 19, 2021, the government's second wave of discovery was produced well after the discovery deadlines had passed. This production demonstrated that the government's March 31st, 2021 written representation that it was not in possession of additional Brady material was simply untrue. Again, Brady material being evidence that might be exculpatory to the defense. B, withholding information implicating an investigating officer in extensive corruption. During the time the government was supposed to be repairing the legal and factual flaws in the superseding indictment, James Finch's counsel continued to try to resolve without court intervention discovery disputes relating to Brady issues, sealed pleadings, and redacted 302s. Those are the FBI notes, the formal ones. Unsuccessful in our efforts, on October 22nd, 2021, James Finch was forced to file a motion to compel the production of redacted FBI notes and sealed pleadings. Finch's motion detailed a history of the government's discovery violations, including the government's misrepresentation on March 31st, 2021, that it was not in possession of any additional Brady material. Footnote. To be frank, at the time, the defense simply could not understand why the government clearly was suppressing evidence, including Brady material. It was unclear why the government would repeatedly violate court orders, suppress evidence, and intentionally evade and obstruct its basic discovery obligations. Of course, it became clear why the government engaged in this misconduct once the information relating to Major Jimmy Stanford, Agent Borghini, and former Chief Assistant State Attorney Greg Wilson began to slowly emerge, and once the court ordered the production of all grand jury transcripts. Whew. Wow. All right, I'm going to continue reading as much of this as I can and I think is appropriate for tonight. 76 pages long. We're going on to page 12. This is going to take me probably a couple of shows to actually show you all of this. But I will, I'll keep going right after this.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at. Right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are welcome. Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-3777.
All right, let's continue on. This is, the defense says they couldn't understand why the government was suppressing evidence, and they say it has to do with the people I just named. So let's go on. On November 9, 2021, the court granted James Finch's motion to compel over the government's objection and express representations that the redacted material was not Brady, was not exculpatory, possibly. The unredacted material was produced on November 12, 2021. A review of that unredacted material was shocking, unequivocally demonstrating that the government's representations of no Brady were false. Specifically, the unredacted statements from government witness Michael White, the former Lynn Haven city manager, and David Mickey White, the owner of ECS, not related, clearly revealed substantial misconduct by the government, as well as various purported witnesses for the government. Even more incredibly, we'll go back up to that in a minute. Even more incredibly, see where it continues. The reports implicated Bay County Sheriff Officer Major Jimmy Stanford in criminal conduct, much of what occurred while investigating this very case. The unredacted reports further detailed a close personal and financial relationship between Major Jimmy Stanford and Derwin White, whom the government had previously identified to the Tallahassee grand jury as one of the targets of the investigation. Footnote, despite the government's representation otherwise, Major Stanford has been intimately involved in this case since its inception. The government argues that the overwhelming evidence of Major Stanford's corruption, including the government's knowledge of this evidence, is, quote, immaterial, end quote, since, quote, he is not going to be called as a witness, end quote. Major Stanford, quote, who was present for some of the interviews conducted by the FBI, was never expected to be a government witness in this case, end quote. Such an argument strains credulity. The unredacted reports further seriously brought into question the investigative tactics, professional judgment, and honesty of lead agent Borghini. Despite receiving information from multiple sources that Major Stanford was involved in significant criminal conduct and was intimately connected to the targets, neither Agent Borghini nor the government notified the Bay County Sheriff's Office, the Bay County Sheriff, nor attempted to remove or isolate Major Stanford from the ongoing investigation. And this was a question I witnessed on the last day of the evidentiary hearing 3.5 weeks ago, when FBI Special Agent Borghini was on the stand, and the defense asked this question: did you do anything to either notify the sheriff or take Major Stanford off the case so that he wouldn't be participating in the ongoing investigation of his people with whom he's allegedly associated? To which Agent Borghini said, no. I saw that happen. On November 16, 2021, the government suggested that its decision to suppress this critical information was driven by its lack of confidence in our ability to control James Finch. The government further criticized the court. Criticized the court? That would be Chief Judge Walker, stating that the court directed production without reviewing the redacted material or making a determination the material is Brady. Armed with these unredacted revelations at the end of last year and evidence that the government solicited false testimony, the defense filed a motion to dismiss the second superseding indictment, requesting production of all grand jury transcripts, agents' notes, and reports. In response, the government eventually conceded that some of the allegations against Major Stanford may be true, but characterized the allegations, which originated from the government's own cooperating witness, as not Brady, not exculpatory. It wouldn't help the defense. The government's position that such information was not Brady was both legally and factually unsupportable. The court ordered immediate production of all grand jury transcripts. Again, that only happens in less than 1% of these cases. Agent reports and notes by March 1st, 2022, and set the matter for an evidentiary hearing, which I attended. Now we're talking about that hearing in Tallahassee 3.5 weeks ago or so that I attended. Defendant James Finch subpoenaed 8 witnesses to testify at the evidentiary hearing, including David Mickey White, the ECS owner, Michael White, former Lynn Haven city manager, not related, Chris Forehand, city engineer, Adam Albritton, city attorney, Antonius Barnes, former commissioner, Agent Borghini, Major Stanford, and former chief assistant state attorney Greg Wilson. Over the course of 3 days, the defense presented evidence demonstrating: 1, multiple and repeated flagrant violations of court orders and suppression of Brady material; 2, prejudicial and prosecutorial misconduct before the grand juries; and 3, illegal use of an informant to invade the defense camp in violation of the Sixth Amendment. After the conclusion of the defense's presentation on Wednesday, so after the evidentiary hearings were over, the government submitted 13 exhibits and called. After the conclusion of the defense's presentation, so this was the last day of the trial. Still, the trial is still ongoing at this point in this document here. The government submitted 13 exhibits. So the government waited for the defense's final presentation, and during the hearing submitted 13 exhibits and called 1 rebuttal witness, retired Agent Borghini, the sole witness who testified before each grand jury. A, multiple and repeated violations of court orders and intentional suppression of favorable evidence. The evidence is, I wanted to look at this footnote here. Despite the obvious relevance of Agent Borghini's handwritten notes of his repeated contact with Greg Wilson, the government indicated that it would prohibit Borghini from testifying pursuant to James Finch's subpoena about anything related to Wilson. While the court was in recess over the weekend, James Finch served a subpoena on Wilson for his appearance on Monday, the second day of trial. All right. The evidence established that the government intentionally violated court discovery requirements dozens of times in ways both large and small. The government's misconduct was intentional, flagrant, repetitious, and incredibly prejudicial, striking at the very heart of the truth-seeking process. Several instances of misconduct are worthy of highlighting. 1, failure to produce all witness reports and agent notes. On December 6, 2021, based on evidence of serious government misconduct, Defendant James Finch moved to dismiss the second superseding indictment with prejudice. The defense also moved to compel the production of all grand jury transcripts, all witness reports, and all agent notes. On February 22, 2022, this year, the court granted Finch's motion to compel. So the defense got what they asked for. Finding that the defense had made the necessary showing, demonstrating a particularized need for the requested materials, the government was instructed to produce the transcripts of testimony before the government's instructions to grand juries 1, 2, and 3, all witness reports, and the notes of agents conducting the interviews by March 1st, 2022. Unfortunately, the government utterly failed to comply with this court order as well. Instead, it regarded the court's instruction in the most flagrant fashion. Rather than complying or seeking an extension, the government made 7 late productions, 1 late production during the evidentiary hearing, 3 late productions after the conclusion of the evidentiary hearing 3.5 weeks ago or so. The government never sought an extension. All right. So these are government's discovery production history. These are some of the people who have been interviewed by the FBI in this case. You can look through this. I'm going to let you look through this and screenshot it later. I'm not going to read all of this. But there's some interesting names in there. All right. 2, Major Jimmy Stanford. Major Jimmy Stanford is a senior law enforcement officer with the Bay County Sheriff's Office. He participated in the investigation from the beginning. Based on the information that was disclosed on November 12, 2021, the government led the defense to believe that it first learned of criminal allegations against Major Stanford on November 26, 2019, from David Mickey White, owner of ECS, who pled guilty. And again on December 11, 2019, from Michael White, who pled guilty, former Lynn Haven city attorney. As revealed below, however, additional late discovery proved this to be untrue. On March 29, 2022, which was 28 days after, quote, all reports were due, and a mere 2 days before the evidentiary hearing for which Major Stanford had been subpoenaed as a defense witness, we received 6 redacted FBI reports from so-called confidential human sources. So these might be informants. Based on the unredacted, newly released information, a confidential human source informed Agent Borghini on May 10, 2019, that Target, we don't know who that is. We can't read that, and I'm not going to guess, although I have my guesses. So Major Stanford admitted on March 31st, 2022, that Agent Borghini and the lead prosecutor had been notified of his relationship with Target Derwin White since the inception of the investigation in April 2019, including various expensive gifts and services to Major Stanford had received from Derwin White. Now, these were questions asked on the first day of the hearing by the defense attorney. The first time the government ever came to you, 20, and asked about it was March the 2nd, 2022. Stanford said, I had spoken to Major Coons Borghini about things with Derwin, my relationship with him and these things. Defense counsel, really? Stanford, yes. How long ago did these conversations start? Stanford, when the case first started. So several years ago, yes. That was the first raised with you by Mr. Coons, who is the lead prosecutor for the government. And Special Agent Borghini, the FBI? Answer, and the sheriff. I talked to him and told him of my relationship with Derwin. In short, the suppressed evidence, and that's the end of the questioning. Now we're back to the narrative by the defense. In short, the suppressed evidence regarding Major Stanford's corruption was clear that the government illegally withheld Brady material. Despite knowing of these allegations, which cast serious doubt on the credibility of the government's entire case, the government did not recuse or remove Major Stanford from the investigation. Defense counsel asked, did you do anything to either notify the sheriff? So this is what I saw on the last day. The defense attorney asked Special Agent Borghini, retired, when he heard about this relationship, did you do anything to either notify the sheriff or take Major Stanford off the case so that he wouldn't be participating in the ongoing investigation of his people with whom he's allegedly associated? And Agent Borghini said no. He did not do anything. In fact, as reflected below, according to the government's documentation, Major Stanford participated in at least 36 interviews after the FBI and lead assistant United States attorney learned of Stanford's close personal and financial relationship with then target Derwin White 24 interviews after confidential human source, an informant, provided Agent Borghini with specific information regarding Major Stanford's corruption, and 15 interviews after David Mickey White, who owned the company, and Michael White, the former Lynn Haven city manager, provided Agent Borghini with additional information regarding Stanford's corruption. And these are the names of people who were interviewed by the FBI. I'll do this so you can see them. Not produced means the government still had not produced that information as of this writing. All right. Despite court order, the government did not provide a single rough note from Major Stanford, even though the government had represented in writing to defendant James Finch on March 31st, 2021, and defendant Margot Anderson in September 2020, that the United States has advised all agents and officers directly involved in the case to preserve all rough notes. Both Major Stanford and Agent Borghini testified that the government never instructed them to maintain their notes. This was asked by the defense attorney. Did anybody tell you, we may need your notes, don't destroy them? Major Stanford said no. The defense attorney asked, you would have been told, at least pursuant to the representation made to us in one of the letters, that all agents had been instructed to retain all their notes. Is that accurate? Agent Borghini said, no, I don't recall receiving that instruction. In fact, we know now that Major Stanford destroyed his notes after the interviews. This information was suppressed in violation of the court's order and in direct contradiction to the government's representation that all officers and agents were instructed to preserve their rough notes. 3, the government's repeated suppressed Brady material. Again, if you're just joining, Brady material is material that could be exculpatory for the defense. As demonstrated herein and presented during the 3-day evidentiary hearing, the government's multiple March 1st through April 13, 2022 late productions that missed the deadline ordered by the court clearly contained significant Brady material. Each late production constituted a violation of this court's orders. One final late production is worth mentioning. The multiple interview reports of Samantha Lind, which were withheld, and I don't know who she is, are extraordinarily disturbing. Here we go. Miss Lind was an ECS employee. Samantha Lind, she informed the government in 2019. We don't know what. It's redacted. In short, evidence being used in this prosecution was fabricated. The execution of a federal search warrant was leaked to criminal targets. The 2019 report was not disclosed until March 1st, 2022. Other important examples of misconduct include withheld agents' notes, which often contradicted the 302s, which are the formal FBI notes after they interview somebody, as well as Agent Borghini's testimony before one or more of the grand juries. For instance, the FBI 302 form of Finch's interview on July 13, 2020 states, and we don't know what it states, But Borghini's notes, which were withheld until July 17, 2021, contradict the notes. The suppressed Borghini notes indicate that James Finch stated that he sold the motorhome to Lee Anderson, not that he sold the Andersons a motorhome. In light of all the circumstances, the distinction is important, and we don't know why because it's redacted. Other witness reports include impeachment evidence against the government's cooperating witnesses and evidence contradicting the charges. The evidence is obviously favorable to the defense. It was repeatedly and flagrantly suppressed in violation of the court's order. Dismissal with prejudice should result. B. Multiple productions after the conclusion of the evidentiary hearing, which again took place just 3.5 weeks ago. This is amazing. As indicated above, the government made multiple late productions after the conclusion of the evidentiary hearing. On April 8, 2022, the government produced 53 documents within a folder titled BCSO Notes, Bay County Sheriff's Office. Incredibly, 41 of the 53 documents were available and uploaded on April 5th, 2022. In other words, they were available and uploaded during the evidentiary hearing, but were not given until after the conclusion of the evidentiary hearing. Wow. Without notice to the defense. On April 11, 2022, James Finch requested an explanation as to why the government did not provide all the Bay County Sheriff's Office notes prior to the commencement of the evidentiary hearing. On April 12, 2022, the government responded, claiming that its efforts were diligent, yet conceded that it did not seek rough notes from the Bay County Sheriff's Office until April 1st, 2022, despite a contrary court order and representations to the contrary. The government's repeated disregard for this court's orders has been intentional and flagrant, and its excuses have been at best disingenuous. The government has attempted to blame its latest defiance on the fact that the material was not in the FBI case file. The court's February 22, 2022 order does not limit the scope of witness reports and agents' notes to only those within the FBI case file. Footnote. The government's practice heretofore had been to notify defense counsel via email when additional material had been uploaded to the U.S. Attorney's File Exchange, as it had done previously on other dates. Other than obfuscation, there is no legitimate reason why the government would fail to notify counsel defense of additional production. Of course, Agent Borghini testified that notes were often never transcribed into 302 reports, the official formality of it, as required. Instead, he ignored FBI policy and put them in a folder or something like that. After he retired, he was able to locate a notebook that he had that may not have been marked. This is what he said under oath in the evidentiary hearing. But according to the FBI Evidence Management and Operations Policy Implementation Guide, an FBI agent's original interview notes should be filed in the 1A section of the case file. It required the production of all, the court order required the production of all witness reports and the notes of agents conducting the interviews. Frankly, the court could not have been clearer. Instead of complying, the government repeatedly and flagrantly disregarded this court's orders, suppressing significant Brady information. As a result, dismissal is warranted. 2. Chris Forehand, FBI 302s and immunity letter. Again, remember, 302s are the form of the FBI notes. And Chris Forehand is the former, or I guess maybe even still, the city engineer, Panhandle Engineering. The government's use of Forehand's testimony is another dramatic example of suppressing Brady information and actively misleading the grand jury and the defense. Forehand is the principal witness against Finch in the transfer of Forehand's used motorhome to Lee Anderson, the defendant Margot Anderson's husband. Forehand's statements to the government as recounted to multiple grand juries by Agent Borghini are also the critical evidence in the false statement, count 26, of the superseding indictment. Lee Anderson, a Vietnam veteran, has been friends with James Finch for over 40 years. In fact, Lee Anderson has been employed by Finch for decades, working for Finch's race team and on his boat. Finch was Lee Anderson's best man when Lee married Margot in 2001. So Chris Forehand, the city engineer's involvement in the multiple indictments permeate every aspect of the case. He is referenced in multiple reports and the FBI 302 notes. He was involved in World Claim. These are all the elements of these charges against the defendants. ECS, the hurricane debris pickup, the design build projects, the 17th Street ditch project, and the 1.5 cent sales tax allegations. Just as we would later learn that the government had its nose in our Sixth Amendment tent, attorney-client privilege, the government's characterization of the incriminating information provided by Forehand against Finch was dubious at best. As a result, we subpoenaed Forehand to the evidentiary hearing. In the initial indictment, this is a footnote now. In the initial indictment, Forehand is Individual A Lynn Haven public official, that strongly recommended to the city manager that Lynn Haven select the World Claim as the city's public adjuster to assist Lynn Haven with the documentation and adjustment of its claims with insurance companies. ECF Forehand offered the city manager a bribe in the form of some of the money that was going to receive from securing a deal between the city and World Claim. In the superseding indictment, the government adds that this same Individual A, Chris Forehand, is one of Lynn Haven's engineers and recommended to the city manager that Lynn Haven select World Claim. In the second superseding indictment, Forehand is the city engineer. Forehand was identified as the owner of the used motorhome sold to Lee Anderson, though even this narrative factually is a moving target. 3. Background on Chris Forehand. On July 19, 2021, the government produced 3 FBI 302s purporting to be debriefings of Forehand. According to the documents provided, Forehand's first interview was held on July 29, 2019 at Panhandle Engineering's offices. Forehand was interviewed again on September 3, 2020, but this time represented by counsel. Forehand was interviewed yet a third time on March 21, 2021 with counsel present via Zoom. After he was subpoenaed by the defense to appear at the evidentiary hearing on the motion to dismiss, Forehand was interviewed yet a fourth time on March 11, 2022 with counsel present. The government's July 19, 2021 production also included several witness statements implicating Forehand as essential to the World Claim conspiracy, participating in kickbacks and cash payments to public officials, and bribing former city manager Michael White to award them a FEMA monitoring contract to Tetra Tech. And we can see here at the bottom of the footnote, let's look at footnote 17. The government has represented to this court that former Agent Borghini worked primarily with Bay County Sheriff Office investigator Jeremy Mathis. Interestingly, the interview of Forehand was not with investigator Mathis on August 23rd, but with Major Jimmy Stanford instead. Footnote 18. Who's Tetra Tech? Well, it's a California-based consulting and engineering firm that was retained by the city of Lynn Haven to provide monitoring services following Hurricane Michael. To date, Tetra Tech has received over $5 million in fees from Lynn Haven after former city manager Michael White awarded Tetra Tech the FEMA monitoring contract in 2019. Forehand is now, quote, senior management for Tetra Tech. Indeed, multiple witnesses stated that Forehand pushed World Claim onto the city for his personal financial gain and promised kickbacks to other public officials. Now we have a lot of redacted stuff. All right, these are witness statements here. So let's go to here. Prior to returning the second superseding indictment, the government acquired more incriminating statements and testimony regarding the World Claim arrangement between Chris Forehand and Michael White. All of these are witness statements that are redacted. Incredibly, the government was fully aware of the allegations surrounding Chris Forehand before his interview on August 23, 2019. Yet, all FBI 302s of Forehand interviews that had been provided to the defense were devoid of any mention or reference to world claim. This is really remarkable. Even though Chris Forehand was instrumental, according to all of those witnesses, in the city choosing world claim through city manager Michael White, who has pled guilty, in the FBI interviews with Forehand, the FBI didn't ask Forehand about this, according to the notes. Wow. The independent bribery conspiracy contained in each indictment against Margot Anderson, who has denied all complicity in the Forehand world claim conspiracy. And while reviewing this contradictory material, the defense continued to ponder the court's initial question of reference. So if there's going to be a conspiracy, what makes up the wagon wheel? Who's the hub? Who are the spokes? Who's the rim? These are the questions that the judge asked. Quote, one circuit at least has described this issue as looking at it like a wagon wheel. And you've got a hub and spokes, but it's not enough to just have a hub and spokes. You've got to have a rim. You've got to be able to connect them up. The judge said, but for the life of me, I don't see, if we look at it as a wagon wheel, with either Finch or Anderson being the hub or the rim, how world claim would be part of what you allege is the conspiracy. That is a single unified conspiracy as opposed to an uncoordinated smaller conspiracy. And then I'm going to have to ask the same question for ECS. I'm not sure any of these allegations all connect to Mr. Finch. All evidence pointed to Forehand, Chris Forehand, as representing the spokes, not James Finch or Margot Anderson. Yet the Borghini 302 interviews of Chris Forehand simply did not bear this out, nor did Agent Borghini's testimony before multiple grand juries. And the government never produced an immunity agreement between the Department of Justice and Chris Forehand. All the while, the defense continued to press the government for production of materials which clearly undermined their core case, especially as it related to the dubious allegation regarding James Finch, Margot Anderson, and the used motorhome. Based on these critical inconsistencies and the wholesale lack of honest disclosure by the government, the defense pressed forward with a subpoena for Chris Forehand to testify at the evidentiary hearing on March 31st, 2022, just a month ago. 2 days prior to the actual hearing, however, the government notified the defense that Forehand's attorney indicated that his client would not answer questions and instead would invoke his Fifth Amendment right to remain silent. Forehand's attorney indicated to the government that there may be some inconsistencies between Forehand's testimony and Michael White's testimony about world claim. Forehand's attorney further indicated that his client's testimony would not be helpful to the government. The government also notified the defendants that at this late stage, 2 days before the evidentiary hearing, it was in the process of granting Forehand immunity. Let's look at the footnote. Finch has consistently maintained his innocence. Regarding the use of the motorhome, he has repeatedly stated that he obtained the motorhome from Forehand and then sold it to his longtime friend Lee Anderson. He has consistently stated that Margot Anderson had nothing to do with the transaction. James Finch 302, okay, these are the citations. On the other hand, the government's false narrative presented to multiple grand juries and the public has changed repeatedly. At one point, it was alleged that Finch arranged to have Forehand sell the motorhome to Margot Anderson. In the same charging documents, the early ones, the allegations changed from selling the motorhome to Margot Anderson to receiving a free motorhome from Finch. Indeed, Agent Borghini's testimony before the Pensacola grand jury is replete with inaccurate testimony about the motorhome transaction. Then there's some redaction, which does not contain Margot Anderson's signature or name on any of the title documentation. Bill of sale, which does not contain Margot Anderson's signature or name. All right, so let's get on with this. On March 31st, 2022, the government disclosed to the defense that Forehand was interviewed on March 30, 2022, and offered immunity. Chris Forehand was offered immunity. According to the government, it had not received a signed document from Forehand's counsel
The government's email attached typed interview notes indicating that it would forward the completed FBI 302 and immunity agreement as they are available. On April 12, 2022, so after the evidentiary hearing, after the defense continued to insist on honest and complete production, the government finally provided the FBI 302 for Forehand's interview, which had been conducted on March 30th, 2022, one day before the evidentiary hearing. Attached heretofore as Defendant's Exhibit 86, clearly inconsistent and contrary information existed regarding Chris Forehand's role in this case, and clearly the government intentionally suppressed these contradictions and reckless exaggerations throughout the case to multiple grand juries. Footnote: incredibly, the report indicates that it was entered and available on April 1st, 2022, but the government waited 11 additional days before providing the report to the defense. Wow, that's the violation of the court order if that's true. Although many additional examples exist, one more is worth detailing. All right, and I'm going to go ahead and detail that one more. But first, I want to thank one more sponsor, and then I'll continue on a little bit more. Americans for Prosperity is the largest grassroots organization advancing policies that help people improve their lives. AFP Florida seeks to end corporate welfare, expand energy options, and reform education and healthcare by giving people more choices. Sign up today and volunteer at americansforprosperity.org. So this is a 76-page document. I am on page 33. I'm going to try to, I'll get through about half of it tonight, and I'm going to try to do the other half tomorrow. Number 4, April 13, 2022, Dee Dee Rowan, Hidden Notes. Within the government's July 17, 2021 late production, the defense received an FBI 302 report of interview of Lauren Brubaker, which was conducted July 30, 2020. So she is, I believe, I could be wrong, so check me on this one, okay? I believe Lauren Brubaker was with WorldClaim, right? The adjuster with WorldClaim. And she was dealing with things like FEMA and the city. So that's she was working closely. We'll find out how closely with Mike White, the former city manager who has since pled guilty. On April 13, 2022, for the first time, the government after the evidentiary hearing, the government provided a single word document containing notes from an interview Agent Borghini conducted with Attorney Rowan. Attached hereto as Defendant Exhibit 86. The interview purportedly occurred on August 25th, 2020, but was never formalized into an FBI 302 document, which is when they formalized their interviews, like so many of the other interviews in this case. The notes of the interview reveal clear, unmistakable Brady material. That's material that could be exculpatory for the defense, that was suppressed by the government and not turned over to the defense until after the evidentiary hearing. The information unquestionably undermines Michael White's and Forehand statements to Agent Borghini implicating Margot Anderson in the WorldClaim affair. The notes further discredit Agent Borghini's sworn testimony before grand juries number 2 and number 3. You can see it's redacted, so I don't want to guess. This explosive reference directly contradicts the government's theory and the testimony presented to multiple federal grand juries by the lead prosecutor through Agent Borghini's testimony. And to add insult to injury, this contradicting information was suppressed by the government and not turned over to the defense until after the evidentiary hearing was concluded. Footnote: former city commissioner Dan Russell was interviewed by Agent Borghini on September 1st, 2020. Sheriff Tommy Ford and Major Jimmy Stanford were also present for the interview, wherein Russell indicated a redaction. Despite this clear Brady material, the Russell 302 notes, the FBI notes, were not produced until July 17, 2021. Dan Russell's FBI notes
attached. Okay. In sum, this court's orders were flagrantly disregarded. Critical favorable information was suppressed, and false and misleading information was presented to multiple grand juries, including the Pensacola grand jury. As a result of these grave violations of law, dismissal is warranted, and it cites case law, admonishing and ultimately sanctioning Assistant U.S. Attorney after dismissal of the indictment for recklessly pursuing prosecution based on fabricated statements and speculative grounds. So I've used the term malicious prosecution, but I guess the legal term is reckless prosecution as opposed to malicious prosecution. I'm guessing on that. I'll try to be more precise with my language. C, dismissal with prejudice is the appropriate remedy for these flagrant, deliberate, repeat violations of the court's orders. Dismissal of the second superseding indictment with prejudice for deliberate, flagrant, repeat violations of court orders and intentional suppression of Brady information is appropriate under the court's supervisory authority. In the United States v. Chapman, 2008, the circuit court stated that the government's reckless disregard for its Brady obligations, as well as its misrepresentations in this case, warranted dismissal of the indictment. So they're citing case law. The failure to produce documents and to record what had or had not been disclosed, along with the affirmative misrepresentations to the court of full compliance, support the district court's finding of flagrant prosecutorial misconduct, even if the documents themselves were not intentionally withheld from the defense. Other courts have similarly recognized that a prosecutor's reckless disregard of Brady and other discovery obligations can constitute flagrant misconduct, particularly where, as here, the government refuses to acknowledge its errors. See United States v. Kajoyan in 1993. The government's discovery violations, misleading statements, and failure to accept responsibility for its wrongdoing constituted flagrant misconduct. And it quotes other case law. Discovery violation justifies dismissal of the indictment where the government did not produce exculpatory evidence before the trial, and the government misrepresented the materials it had disclosed and admitted that it did not keep a thorough discovery log to keep track of what had been disclosed to the defense. Affirming the district court's dismissal of an indictment with prejudice, explaining that such a result was appropriate within the range of reasonable and appropriate remedies. So what you see is the defense is providing case law backing up their arguments here. In Bundy, the government likewise disregarded its discovery obligations despite a clear court order. As additional documents came forth during the trial, the district court held a series of hearings, eventually deciding that the trial could not go forward and that the indictments must be dismissed with prejudice. The appellate court affirmed, so it went to appeal. The appellate court affirmed, concluding that the district court did not abuse its discretion in dismissing the indictment with prejudice. And it has other case law. Dismissing an indictment with prejudice for total ignorance of the discovery obligations of the government through its agents. More case law finding that government's Brady and Giglio violations, unwarranted denials, and delays prejudiced the defendant to such a degree that dismissal of the indictment with prejudice was warranted. The government will argue, of course, that the results in Bundy, Castro Gonzalez, and Lyons do not apply here. In other words, the case law that we cite, the government will say does not apply here, since the late Brady disclosures, in this case, occurred during, in those cases occurred during trial. So what the defense is saying is that the government's going to respond to our filing here, and they're going to say that was all different because that occurred during the trial. We're not even at the trial stage yet. Okay, that's what they're anticipating that the government will say. The specific timing of the discovery of the repeated flagrant intentional violations, however, cannot singularly control the court's final decision as to what discretionary sanction is appropriate. Otherwise, the defense would be punished for its diligence, and the prosecution rewarded for its intentional, repetitive misconduct. Here, the government indicated on March 1st, 2020, that the material it was producing represents the bulk of the government's anticipated Jenks production. It further indicated that it had produced all Brady information in its possession on March 1st, 2021. Despite these representations, the defense kept digging and insisting on production. And but for the court's February 22nd, 2022 order and the evidentiary hearing, the government would have suppressed critical Brady material for at least until trial and likely longer. See United States v. Burke, holding that some limitation on disclosure delay is necessary to protect principles articulated in Brady. The government's intent to suppress Brady material, exculpatory material, at least until trial is evident by its conduct and by its written response to defendant's motion to dismiss. Quote, this is what the government said when the judge ruled. Well, let me just read it so I don't say something wrong here. This is what the government had said previously. The 11th Circuit has noted that a late disclosure by Brady error will be reviewed by the 11th Circuit under constitutional standard, not the local rules of the district. Of course, the record supports the more probable conclusion that the government had no intention whatsoever to turn over the Brady information received due to the court's February 22nd, 2022 order. Either way, the government's intentional, flagrant, cavalier attitude toward discovery and the court's orders should not be tolerated in any form. It's another case precedent, recognizing that it would eviscerate the purpose of the Brady rule and encourage gamesmanship were we to allow the government to postpone disclosures to the last minute during trial. For these reasons, the defense says, the analysis and reasoning in Bundy, Castro, Gonzalez, and Lyons are helpful. Those are previous cases. Of course, footnote says, the sheer magnitude of the violations, along with the disturbing conduct in multiple grand juries and contact with represented parties, eclipses the misconduct described in Brady. Okay, let's go just a little bit further. Number one, the government's conduct was flagrant. The government's misconduct was repeated and flagrant, yet the government attempts to carve out the same exception as in Brady, stating that it was not guilty of flagrant misbehavior since many of the documents were in the hands of other agencies. So the FBI is saying, look, other agencies like the sheriff's office had some of these documents. We gave our stuff. As recognized by the district court and affirmed by the appellate court, however, the prosecution is deemed to have knowledge of and access to anything in the possession, custody, or control of any federal agency participating in the same investigation of the defendant. And they quote case law here. A prosecutor's office cannot get around Brady by keeping itself in ignorance or by compartmentalizing information about different aspects of the case. And to the extent that any government agencies or actors, although their own flagrant misconduct, through their own flagrant misconduct, failed to make known exculpatory information, the flagrant nature of such conduct will be imputed to the prosecution team. The government here has attempted to absolve itself of violating the court's orders by blaming the agents and local investigators. So here the defense is saying that the prosecutors, the government, has attempted to absolve itself of violating the court's orders by blaming the FBI and the sheriff's office, and even the defense counsel. For instance, the government has suggested that it did not provide the grand jury excerpts containing the solicitation of false and misleading testimony of Agent Borghini until months later because the defense counsel did not specifically ask for the transcript. The court should reject this argument. Indeed, the government conceded that it never even asked the Bay County Sheriff's Office for the notes before April 1st, 2022. Blaming others for what is clearly significant violation of the government's legal obligation is unpersuasive and contravenes the high ideals of the Justice Department. The undisputed evidence demonstrates that the government's misconduct was intentional and flagrant, whether malicious or not. And then it quotes another case, more case law, concluding that flagrant misconduct, this is interesting, remember this, flagrant misconduct does not have to be intentional or malicious. finding that the government's discovery violations, misleading statements, and failure to accept responsibility for its wrongdoing constituted flagrant misconduct. Number 2, dismissal with prejudice is justified. Again, we recognize that dismissal with prejudice is an extremely serious remedy. As the Bundy court reasoned, a lesser remedy is always available in theory, but no lesser remedy would fully address the damage caused by the government's repeated flagrant misconduct. Citing case law, what the phrase no lesser remedial action is available means is that any lesser sanction will put the defense at a greater disadvantage than it would have faced had the government produced the Brady material in the first place, thereby perpetuating the harm from a violation of a federal constitutional right. In Chapman, the court explained that the mistrial remedy would advantage the government, probably allowing it to salvage what the district court viewed as a poorly conducted prosecution. Indeed, allowing the government to take this case back to the grand jury for a fourth time would be fundamentally unfair. Such a result would only encourage the government to suppress evidence, return to the grand jury repeatedly to correct its errors and misconduct, and continue with prosecution indefinitely, all the while learning the defense case while testing its own dubious theories. There is also the related need to impose a sanction that will deter future misconduct that has occurred here. As in Brady, the government has failed to acknowledge and confess any wrongdoing during the course of this case. Rather than accepting responsibility, the government in Bundy and the government here have blamed the defense for not requesting more specific information. Quote, given the government's efforts to minimize the defendant's discovery request and its misrepresentations to the district court in such a high-profile case, the district court understandably sought a remedy that would reinforce the seriousness of the violations here. In this case, the government has violated its constitutional duty of fairness with flagrant disregard of the court's orders to the detriment of the defendant's constitutional rights. Accordingly, dismissal with prejudice is an appropriate remedy under this court's supervisory authority. Any lesser sanction would be like endorsing the government's misconduct. I'm going to end it there on page 42 out of 76. And I will continue to read the rest of it, the remaining pages, tomorrow. I believe tomorrow. I should be able to do this tomorrow. So where are we? Again, that was the defense's filing to the court. Now the prosecutors are going to file a response, which they did not defend in a live presentation in front of the judge. They're just going to write it. And then the defense, I believe, has another chance to respond to that. And then I believe at the end of May or early June that Chief Judge Mark Walker will issue his ruling whether or not to dismiss this because of what you're hearing here. This is limited to the evidence presented in the evidentiary hearing. If this goes to trial, there's going to be tons and tons and tons more. There are going to be people pulled up there, put under oath, like in the sheriff's office, the FBI, Chris Forehand, the city engineer, who for some reason is getting really great treatment. I mean, city engineer Chris Forehand is implicated all throughout all of the indictments. Bribery, kickbacks, all kinds of stuff in the indictments. But for some reason seems to be getting treated differently. I'm still looking to see, I want to see the government's documentation to see if he's really going to get full immunity. And for what, right? For what? Very, very interesting stuff. Okay. But with that, I'm going to wrap it up. I know it's been a different kind of a show, but I think you need to hear this stuff. I think you need to know these things so that we can form our opinions in the court of public opinion based on the evidence. And I'm really looking forward to seeing the government's evidence because they wouldn't give it in front of the judge. I am looking forward to seeing that too. And if it shows evidence of guilt, you're going to hear it. You're going to hear it here. I'm going to continue to go deeper than you're going to get anywhere else. All right. With that, I want to thank my sponsors. And if you would like to support my efforts, here's how you can do it. You can become a patron, and it's sort of like giving a tip every month. It's anonymous, it's easy, and you can quit at any time at patreon.com/Bernie Thompson. That's how I can do this stuff, through sponsors and through those of you, it's called crowdfunding, who decide you want to help me do this, because I surely couldn't tell you this if I worked for any of the local news outlets, which I would never do. And that's why I'm not on talk radio anymore either. Patreon.com/Bernie Thompson. I'm determined to continue to give you these independent efforts. All right, with that, I'm going to wrap it up. Thank you so much for being with me, and I will read you the rest of this tomorrow.